and Elder Law Center. We're going to get going in a couple of minutes. It's just 2 minutes before the hour, and just letting you know that we will be starting here. Also, if Laura, if you could just let me know whether my voice is coming through and you can see my video, just to be sure we're all set. Thanks, everybody, and I'll see you in a minute or two. Okay, here we are. It's 1 o'clock in Wisconsin. If you're somewhere else, it might be a different time there, but that's a good reminder that we are going to be talking about mostly Wisconsin issues, Wisconsin law. These are issues for people around the globe, obviously, but I'm only qualified really to talk about these Medicaid issues as they affect Wisconsin residents, because I'm licensed to practice law in Wisconsin, also Illinois and Minnesota, but I really don't have a lot of experience in Illinois and Minnesota regarding Medicaid. So we will be talking about planning for Medicaid and how you should plan so that you and your family do not lose everything you've worked for. But first, I just want to introduce myself. My name is Dan Kraus. I'm an attorney. I've been licensed to practice law in Wisconsin since 1999. And I've been practicing and doing estate planning since 1999. So the turn of the century, as they say. And I have a specialty designation, which is fairly rare. At least in Wisconsin, we only have 7 estate planning law specialists certified. Which is it's just something that people should know, that if you're going to do estate planning, especially elder planning, you should go to somebody who's experienced and knows what they're doing, and not somebody who can also do your divorce and your bankruptcy and anything else. All right, so let's get into it. This, like I say, I am licensed in Wisconsin as well as Illinois. Also, I'm a military veteran. Also very proud of that fact. I was a medic in the military, and before I became a JAG officer, which is the legal, the law office of the military in the Army, where I was. If you can see the slides, I hope you can. The bottom picture is me in my military uniform several years ago, and I'm wearing my BCGs. So anybody that's been in the Army, at least the glasses we call BCGs, those are the glasses that Uncle Sam gives you. And we call them BCGs to stand for birth control glasses, because nobody will go on a date with you while you are wearing those glasses. I've also written a book, Estate Planning in Wisconsin. It's available on Amazon if you'd like to check it out. A lot of stuff in there. It's not written in legalese. It's written in easy language. Most people can understand it, and it's a good primer on estate planning. Also, me and my staff, as well as the law office, are involved in many different organizations, and we receive different kudos and Better Business Bureau A+ rating for many years. And here's just some of our little badges of honor, I guess. So let's talk about long-term care, because that's what we're going to be talking about. There's many kinds of Medicaid, but the Medicaid that I want to talk with you about is Medicaid for the elderly, blind, and disabled, and most specifically and usually for the elderly. That type of Medicaid is what we're going to be focusing on. So just a little statistic that if a person reaches the age of 65, they have more than a 50% chance to end up in some form of long-term care facility for some time. Some people a very short time, some people a much longer time. And also, I just wanted to mention, if you are or a member of your family is in a situation where it looks like you may need long-term care, that is a very difficult situation, and families have a lot of stress over that. So I just wanted to recognize that and not make light of it. We're going to be talking mostly about legal principles, and it's fairly dry, but I realize that there's a lot of emotion and a lot of worry and concern over these things. So it is not something to take lightly. So there are a lot of dangers of getting older. One of the greatest of which is disease. The risk of disease and crippling conditions, etc. We lose mobility. We lose the ability sometimes to think straight, etc. And these are the things that cause the need for long-term care. Some of the things that cause that need for long-term care. So long-term care is expensive. I hope that you never need it, or no member of your family needs it, but if you do, paying for it is very difficult. So here's just some statistics about in Wisconsin, the average costs, or what you might expect to pay in long-term care costs, whether you're in a licensed nursing facility, an assisted living, memory care, sometimes home care, etc. And of course, costs go up every year faster than inflation. So who pays for long-term care? This expensive amounts that need to be paid if a person's going to be taken care of. Well, Medicare does not pay. So when you're 65 and you get Medicare and they pay for all of your or some of your doctor bills and etc., and then your Medicare supplement takes up the slack and pays the rest. Well, Medicare will not pay a penny towards long-term care. Now, many people say, well, Medicare will pay for nursing home stays, and that's limited truth to that. And let me tell you about that. So Medicare will not pay for long-term care, but they will pay for a nursing home stay up to 100 days. And you have to have very specific circumstances where Medicare will pay for up to 100 days. And I'll just talk about that very quickly. It's not long-term care, it's rehabilitative care. Medicare will pay for rehabilitative care, and sometimes rehabilitation is done in a nursing home setting. But it is monitored very closely, and as soon as the person stops rehabilitating, and then they're not expected to get any better, and it's just to hold them at the health level that they are at and support them in living, then Medicare stops paying, even if it's less than 100 days. So if a person goes into the hospital, they have to stay there for 3 days or 3 nights. And if they do stay in the hospital for 3 nights and they go straight from the hospital to the nursing facility, Medicare will then start paying for them to rehabilitate in the nursing home. But if they are not rehabilitating, if they are just there because they need life support, lifetime support, now not necessarily life support, but lifetime support to help them eat, to help them go to the bathroom, to help them get through their daily living, to make sure they remember their pills, then as soon as it gets to that point, Medicare stops paying. So Medicare will not pay, health insurance will not pay. Long-term care insurance will pay. Also, there's other types of insurance, life insurance that has a long-term care rider will also pay for long-term care. But there's limits to these policies, and each policy is different, so you have to know how much your policy is going to cover. And most people, I'd say 95% of the population does not have these policies. It's probably more than 95% of the population, but that's a guess. Does not have a policy of long-term care insurance. So if you don't know whether you have long-term care insurance, I can almost guarantee you do not have it. All right. So VA pensions will pay for long-term care. However, it's limited to $31,000 a year, which is much less than what people really need if they do have to stay in a nursing facility or assisted living. Now, Medicaid, which is the program that we're going to focus on, will pay for long-term care. It will pay for nursing care. It will pay for assisted living, and it will even pay for health care at home. So long-term care at home, it will not pay generally 24/7 care. If a person needs more care than what the Medicaid will provide at the home, which is a few hours a week, then they need to be in a facility before Medicaid will pay for that. But most commonly, people, when they go into long-term care, they pay out of pocket. That means either they pay from their savings or their family pays. So the bottom line is, for most people, you pay for your long-term care until you go broke. And then once you go broke, Medicaid kicks in, and then they start paying. Now, I want to talk a little bit about, because we're going to talk about Medicaid preparation or doing estate planning so that you can qualify for Medicaid later on and have Medicaid pay for your care or a significant portion of your care instead of it coming out of your pocket and your savings and your home or your nest egg. A lot of people have told me in the past that we don't believe in Medicaid planning because we think it's cheating. We think that people should have to pay for their own care, just like the law essentially is designed to do. We don't think that hiding assets is fair to the taxpayer or something that you should legally be able to do. But my answer to them is, I want to help my clients avoid discrimination. There is an inequality in the U.S. healthcare system that leads to discrimination or amounts to discrimination. Now, this discrimination is not based on whether a person, the color of their skin, their religion, their sexual preferences, nothing like that. The discrimination is based on what type of ailment you have when you're older. And the basic discrimination is because of the difference between Medicare and Medicaid. Medicare pays for outpatient and inpatient care. Medicaid will pay for long-term care. Medicare is earned through the Social Security system for anybody in this country who's worked, has the proper citizenship or permanent residency, and pays into the system. When they turn 65, they can get it. And it's relatively inexpensive. It's taken directly out of your Social Security check, and even billionaires have Medicare if they apply for it. Medicaid, on the other hand, is not something you automatically get when you're 65. It's a needs-based program, which essentially means you have to go broke or your assets have to be down below a certain level before the government will pay. And essentially, the level is poverty, even worse than poverty, perhaps. So the discrimination happens because Medicare pays for some illnesses, but does not pay for other illnesses. So Medicare pays. Let's say if you have cancer, your treatment's going to be in the hospital. If you have a heart transplant, your treatment's going to be in the hospital, and then your convalescence is going to be at home, etc. Bypass surgery, dialysis, stroke. These are all outpatient, inpatient type treatment. But if you have Alzheimer's disease, Parkinson's disease, other forms of dementia, COPD sometimes, debilitating arthritis, post-stroke disability, that means that you need help on a day-to-day basis for the daily activities of living, then Medicare will not pay for that. So you have to pay out of your pocket. So what's the discrimination? Well, obviously, if you have a disease that causes you to go broke, that's discrimination compared to the person that has a disease that Medicare will pay for. So if I was going to choose a disease for my old age, I would definitely choose out of the list on the left of the slide. And that's just for financial reasons. Now, I'm not saying that it's good to have cancer. Certainly not. I would never wish it on anybody. But if I was going to choose between cancer and Alzheimer's disease, I would choose cancer because one big reason, I can still keep my money if I have cancer because I can get treatment through Medicare and a Medicare supplement. So what's the government's plan? If you do, or you and your family happen to be unlucky enough to have a long-term care issue, the government's plan, which shouldn't be your plan, by the way, but the government's plan and the nursing homes plan and the county's plan and anybody, almost anybody that talks to you about this will tell you this is the plan that you have to do. You have to spend down your assets until you qualify for Medicaid, which means you have to spend down until you have $2,000 or less. You can keep your home during Medicaid, so you can just save the home, but spend everything else. You can keep one car, even if it's a couple, you're only allowed one car to count. And then you can have burial insurance like prepaid funeral. Other than that, household goods and furnishings. So let's say your furniture and your jewelry, etc. As long as stuff that you've had for a while, they don't count that stuff. Now, people say, "Oh, great! All of my my wealth is in my home, so it's great that I can keep that. So that can go to my kids when I die." But wait, there's more. The government's plan has a plan for after you die. They don't want your kids to get that home. They want that home to be sold to pay for your care. So if you are on Medicaid and you have a home and you keep it during your lifetime, the government Medicaid office in Wisconsin, it's the Department of Health Services, keeps a tab. And every month that they pay your bill at the nursing home, they put it on your tab. And they keep a tab however many months, however many prescriptions, however many everything. And then when you die, they present the bill, they present the tab, and they put a lien on your house. They go after your life insurance. They go after anything that is in your name or transfer. They go after your IRAs, 401ks, all of those things. Now, probably you don't have any IRAs or 401ks left, but just to make the point, they go after it all. And when your spouse dies, they will go after your spouse's assets as well. So be careful, because Just because you can keep your house during your lifetime, don't think that it's safe for your kids. It's not. So the cost of nursing care is about $13,000 a month, going up maybe closer to $14,000 this year. 5 years of nursing care is more than $750,000. Long-term care insurance is a great option for many people. One thing about it, if you're going to get long-term care insurance, I hope that you're in your 40s, because, or 50s maybe. Once you hit 60 or 65, it's very hard to get a policy and it's very expensive. Many people just can't afford long-term care insurance after they've hit about 60, especially if they've had a health issue, because long-term care insurance depends on what your health is. They will give you rates based on your personal profile, and oftentimes they will just say, you're not insurable. We will not write an insurance policy for you. There's also limits per month or day. Usually they talk about, well, $100 a day long-term care insurance. $100 a day seems like a lot, but it will not even pay for most assisted living facilities, the rent in those places. So skilled nursing care it's hardly going to touch. You need probably close to $400 a day in order to cover all the costs that you might need in a nursing home. So back to the government's plan. So let's imagine that someone, dad, we'll call them, dad has $300,000 saved up plus a house. So the $300,000 nest egg is in IRAs or whatever it is. Dad is widowed or divorced, so he's a single person. And he's also got a house that's worth $300,000. Let's just say a $300,000 house with no mortgage on it. He's got it paid off. Now, if he has a nursing home issue and his nursing home stay lasts long enough, then what's going to happen? That arrow shows that his $300,000 nest egg is going to go towards nursing home expenses. Now, after that's gone, he can exempt his house and then get on Medicaid. And then let's say he's in the nursing home for a while longer. And so they're keeping the bill, keeping the tab. Remember, DHS keeps that tab. And now when he passes away, his home is recovered by the state to pay the tab or pay part of the tab off. And so what happens, the real significance of this is that during dad's stay in the nursing home, he really doesn't have security. What if dad needs something that Medicaid will not pay for? What if dad wants to move out of state? He's got no more than $2,000 in the bank. They don't let him keep any of his income except for $45 a month for toothpaste or a haircut, and that's supposed to cover clothing and everything. So he's got no options. He's got no security during his nursing stay, and after death, his kids have no inheritance. All because of a nursing stay. If dad had had cancer and died from that, he may have had millions of dollars worth of treatment, but he would not have had to go broke. So the government's plan does not have to be the plan for you and your family. You and your family should have a different plan. Now, the plan that I'm talking about is not hiding money. It's all legal and it's done within the rules, the Medicaid rules in the state of Wisconsin. As long as the person lives in Wisconsin, I can help you because I know the rules. I can help manipulate the assets, transfer things, convert things from countable to uncountable assets. And when I do this for families, I tell the county exactly what I'm doing. When I get this person on Medicaid, I do not hide the ball. I tell the county workers, here's what we did. We did this, we did that, and we did the other thing. And then that family saves a good portion or sometimes even all of their assets for their use and not for the county or the state. So We focus on knowing the rules and thinking about how can we use the rules not in favor of the state or in favor of the nursing home, but we want to use the rules in favor of our clients. We want our clients to take advantage of all the rules that they can take advantage of. Now, part of planning is gifting. So, in order to save the maximum amount of money for your family and for your security, you have to have family members that you trust, that you can trust with all your stuff, because you're going to have to hand most or all of your assets over to them and trust that they are going to support you during your lifetime. So that is a key part of the plan. There have been several times when a person comes to me and they say, I need this type of planning. I want to save assets. And then I say, tell me about your family and your kids. And either if they say, I don't have any kids, or I don't have any children that I can trust, then we can't do the planning. It's very difficult to do the planning. You really have to have a close relative, usually a child, sometimes a sibling, that you can trust for your lifetime with your stuff. So the SMART plan is to keep your house or your farm or your business and your money, etc., for your security during your lifetime, so that you have something to fall back on, some security, some knowing that you can fall back on something, and then use Medicaid to pay for your care. That's a SMART plan. So in order to get down below the Medicaid threshold, which is $2,000, a house, a car, and some burial assets, gifting is what we do, divestment. So we take the assets, or most of the assets, and we usually transfer those to an irrevocable trust. And this is considered to be a gift or a divestment. So it takes them out of your control, but it puts them in the control of people within your family. And hopefully, from the time that you put those assets in there, you have 5 years of health, or 5 years at least before you need to apply for Medicaid. Now, oftentimes people come to me and they say, well, we didn't plan in advance, and now mom or dad or my spouse needs care now. What can we do? We don't have 5 years. Well, there are things that you can do. You can't save as much as you can when you have the whole 5 years, but we can use the rules to the advantage of our clients, and then get the 5 year. We give away assets and then get a penalty, but it still saves the clients tons of money. Okay. Now, gifts are prohibited within the last 5 years, and if you give away gifts, you will get a penalty, and we'll talk a little bit about that. But there are exceptions. You can give unlimited amounts to your spouse. Sometimes we do that. In fact, often we do that. When one person out of a couple needs Medicaid or needs long-term care, we can save all of the assets if we transfer them to the spouse. Sometimes it's a complicated transfer that has to be done through annuities, but we don't need to dive into that. Just know that if you're a couple and your spouse needs care, we can generally save everything as long as we can transfer everything to the other spouse. Now, if both spouses need care, then it's a different calculation. All right, so what is the gifting penalty? In Wisconsin this year, and it changes every year, Wisconsin, the gifting penalty divisor is $9,599.80 a month. So $9,600, you can give away $9,600. And if you do that and then apply for Medicaid, they will say you are prohibited from receiving Medicaid for 1 month because you gave that gift. So if you give away $96,000, that's 10 months. $960,000 is going to be a 100-month penalty, and on and on. So it's you take the amount that you gave away, you divide it by $9,600, and that tells you how many months that you are unable to receive Medicaid. Now, that penalty period will not start until after you've gotten down to $2,000 or less. So you have to be qualified for Medicaid, then put in the Medicaid application, report all the gifts that you've made within the 5 years, and then that total divided by $9,600, and that's how many months now that somebody is going to have to private pay for you in order to receive Medicaid after the penalty period. So here's an example. If you give a $170,000 gift, then you will not be able to receive Medicaid for 17.7 months if you are otherwise qualified. So we got the 5-year look back. So I want to talk about gifting directly to your children or directly to somebody beside your spouse. You can do that and you can save assets that way, but it's dangerous. It's more dangerous than gifting to a trust. That's the point I'm trying to make. So what if you give it to the child during your lifetime and then, God forbid, your child dies? Now that gift no longer belongs to them. It goes as a part of their estate. Maybe their spouse gets it, right? So now your son-in-law, daughter-in-law owns your house, and they might get married again. They might not like you. They might sell your house and kick you out. You don't know. So you don't want to give the house directly to a child because, God forbid, that child might die. If the child divorces and they own your house, then you've got a problem as well. Your ex-in-law, your ex-son-in-law or daughter-in-law may own part of your house, or you might have to sell the house to pay off the divorce. If your child, God forbid, has their own medical issues or a bankruptcy, now that house is going to be part of their calculation, and they may have to sell it to pay for their care. Also, when you die, if you've given that house to your child and then the child goes to sell it after you die, they are going to get hit with a large capital gains tax problem. If you bought that house a few years back and there's gains in the house, your kid's going to have tens of thousands of dollars to pay on capital gains tax that they would not have to pay if you gave it to a trust and then they get it after you die through the trust. So this slide just explains some of the things that I talked about. So trust planning can avoid these issues. So we use an irrevocable trust when we're doing this type of planning, and the trust is called an MAPT. Stands for Medicaid Asset Protection Trust. So Medicaid Asset Protection Trust is a special kind of trust that's designed to fit within the Medicaid rules and for the family to preserve the assets so that if the person needs long-term care, they can qualify without having to count the assets that are in the trust. Also, after the person dies, the state cannot collect against or put the lien on any property that's in the trust. So those assets can transfer directly to your heirs instead of having to pay off your bills or your Medicaid lien. There's still the 5-year look-back period. So if you transfer to a trust like this, you still have to be concerned about that penalty. The assets are protected for your family. If your child dies, the house or whatever's in the trust is not given to their spouse. It won't be taken if your child divorces. It can't be taken during your lifetime if your child gets bankrupted or anything like that. So it's safe during your child's lifetime. And one of the really great things is when your children get it after you die, if it's properly drafted, then they don't have to pay that capital gains tax on the sale of the property, saving, usually stories that I've heard from my clients, 40, 50, 70, $80,000 in taxes on the sale of the house. That's a big bite. So we have two types of planning that we do in Medicaid cases. One is pre-planning, when we think that the person or the couple that we're planning for probably has 5 years before either one of them would need to apply for Medicaid. And the other type of planning is crisis planning, meaning there's a crisis, somebody needs care right now, or they're already in care and we want to try to save as many of their assets as we can that are left. So we've helped people that have been in nursing care for 3 or 4 years already before somebody thinks to come to us and ask us what they can do. And then we've saved some of those assets and for the family so that they could stop the bleed. All right, so pre-planning, here's the example. So dad, once again, has his $300,000 nest egg plus his $300,000 house. And what does he do? Well, he's healthy. Let's say he's in his 60s or maybe early 70s, and he comes to me and he says, hey, I'm worried about long-term care. I want to make sure that I can give some inheritance to my kids and not have to spend everything, so I have some security during my life. I trust my kids. I think we can put the assets in the kids' care, and there's no danger there. So what we would do is we would follow the left arrow and take $225,000 from the nest egg, and we take the house and we transfer those into this MAPT, this Medicaid Asset Protection Trust. Now, the kids have control of that. So if dad needs it back, there is a back door that the kids can get these assets out of and give it to dad. But in most cases, they just sit on those. They take some out now and then if dad needs something, but most of it or all of it just stays in that trust as security, and dad lives in the house while he's healthy, etc. The right hand arrow just stays with dad. Dad keeps that $75,000. That's his mad money. He uses it to spend on home repairs or vacations or whatever he wants to do. He doesn't have to deal with the kids to use that money. Then after 5 years, dad gets sick or he develops Alzheimer's or something and he needs nursing care. So what happens? Dad and the $75,000 go into the nursing home. Now, dad's still in the nursing home, but the $75,000 is quickly used up. Now he fits within the qualifications for nursing care, and voila, he's on Medicaid. Medicaid pays for his care throughout his life, while the assets that he put in this MAPT are kept by the kids for dad's security. So if dad needs to move or something happens and he needs extra care, things that Medicaid won't pay for, daily massages, oil rub downs, big screen TV, anything like that, the trust, the kids can buy for him so that he's healthy, comfortable, etc., until his death. Then at his death, the children get to inherit. They get whatever's left in that trust without having to pay off the Medicaid bill. They don't have to pay off any debts of dad, in fact, from that MAPT. So in that particular example, we start out with $600,000. Dad needs nursing care. You save $525,000 for the family, where it could have ended up with a zero balance. That would have been the state's plan. All right, so your plan, if it's a crisis, should be different. So this is mom's plan. Now, mom didn't hear that you could do some pre-planning, or she heard about it and didn't think it was worthwhile, and now she needs nursing care. Hopefully she's still available and able to sign things, or she's got a good power of attorney document and a trustworthy power of attorney agent that's her child that can help her do this planning, because right now she needs nursing care. So what do? She's got the same $300,000 nest egg and $300,000 home. In the end, we're only going to save about half of that, not as much as we could save if she did the pre-planning. So what does she do? Well, she comes to us and we do some very complicated calculations, and we decide exactly how much can we save, because we have to work it with the Medicaid regulations. We have to calculate a penalty period because we're going to be making some gifts, and you remember any gifts within the last 5 years are going to create a penalty. So mom's going to have a penalty period, but we're going to make it safe for her to have that penalty period because we're going to put some assets in a specialized annuity that will pay for her care through the penalty period. That's where we lose the $200,000. That's the difference between mom's and dad's plan, because mom has to have the penalty period and dad did not have that. So mom's got a penalty period of, let's say, 27 months, because we've taken 32 months, because we've taken $325,000 after we sold the home and put that into the Medicaid Asset Protection Trust. Mom has moved into a care facility, and we've also taken $275,000 after doing all these calculations, put that in an annuity, and that will pay the Medicaid bill, or I'm sorry, the nursing home bill through the penalty period. That is the money that we're going to lose, that $275,000, because that annuity is going to go down to zero to pay for mom's care. But when it hits zero, we've calculated, so that's the same month that mom's penalty is over with. Now mom's penalty is over with, the annuity is at zero, and she slides on to Medicaid like that with $325,000 in control of the children. So instead of mom having zero, even though she waited until she needed care right away, the family has still saved $325,000 in this Medicaid Asset Protection Trust. And then they hold that for her until her life, during her lifetime. If she needs extra things, they can take money out of that Medicaid Asset Protection Trust, use it for her care, and then anything that's left in there, the children inherit on her death. So just a recap, planning these days is it's a little complicated, but if you do it right, you will avoid the worst scenario, which is you're broke and you rely on the state for all of your care. Planning smart, you may not know where you are, you may not know who your spouse or your kids are, but you're going to be well taken care of, warm, and well fed. You'll also be listening to whatever music you want in the expensive headphones. So I hope this has been useful or educational for people. At this point, we've got a few minutes left, and I would like to see whether anybody has questions. And it looks like we have one question. All right. So I see the question from Randy. Can your child trustee take cash, I guess, out of MAPT? And what's the tax impact? That is a great question. The answer is yes, your child can take money out of the MAPT. It has to be done in a careful way, but since they are the trustees, they can manipulate that MAPT in ways that benefit you. But if they're not trustworthy, they can also manipulate it in ways that benefit them. That is why it is so crucial that you only put somebody that's trustworthy in charge of that, because if your child is untrustworthy and decides they want to steal all your money, they can do it once you put it in that MAPT. So that's a warning that you really, really need to have a trustworthy child. And if you're worried also about that, you can put two children in charge of it so that they have to have two signatures, and then one can, like they have two keys for a safe deposit box. You can't have one and open it up. You need to have both so that now if one of them wants to sell the house, they won't be able to do it without the other one also agreeing. The other part of this was tax impact question mark. Now, I'm not sure exactly what that means, but probably the question answerer was not sure what that means either. So there are tax impacts of a lot of actions that you have. However, the MAPT doesn't have much tax impact. The anything that you put in the MAPT is taxable to you. So if your house is in the MAPT, you get to live in the house, but you also have to pay the home taxes, the real estate taxes. If you have stocks and bonds in the MAPT, you will have to pay the income tax on whatever interest comes on those, even though you may not get that money out of the MAPT, you still have to pay the tax on it. So your child can reimburse you for taxes if you can't afford those, or they can pull out money out of the back door of the MAPT and then gift it to you. It's got to be done in a specific way, though, so that you don't violate the rules around these Medicaid Asset Protection Trust and make it so that the state will say, aha, we caught you. Now all of that money in the MAPT is liable for your care. So we just have to be careful to do it in the right way. But when the children get the assets in the end, there's no tax. So no worries about that. Okay. Question from Amy. How does monthly income from Social Security and pension factor in? Is it possible to ever get to $2,000 with that income? So what happens is all of your income, if you need long-term care, all of your income has to go towards your care. Medicaid only makes up the difference. Now, with a couple, sometimes the well spouse, the spouse that doesn't need care, is able to take some or all of their needy spouse's income. It depends on their income level. But let's just talk and focus on if you're a single person, a widow or widower. So all of their Social Security needs to go into their bank account, not an MAPT. Because if it's going into the MAPT, then every month you're making a new gift and you never get past the 5-year look-back period. So your Social Security and your pension go into your bank account, they come out to pay for your care, and you want Medicaid then to pay the difference between the cost of your care and your income. So if you have a good amount of income and you can cover your care, then you never need Medicaid. But very few people have enough income to cover a nursing home stay. So let's say you have $3,000 a month in income. The nursing home stay is $13,000 a month. Your deficit is $10,000. So your Social Security goes towards paying your first $3,000. Then they kick back $45 that you can use on toothpaste or socks. And then they take the rest and they make it up for with Medicaid. So is it ever possible to get down to $2,000 with that income? So what the rule is, or how they enforce the rule, is they allow your balance in your account to go up above $2,000 as long as when you pay the bill for your care, it comes down below every month. So it can pop up above as long as it gets down to $2,000 again, then it can pop up above and go down to $2,000 again. So yes, that's a good question. And I hope that was a clear answer. But that $2,000 is not a hard limit. It's a limit that you have to get down to every month without gifting anything away. Okay. Now let's see. Is there any other questions? Very clear. Oh, thanks, Amy. Okay. So I see Becky, I think, is trying to ask a question. All we've got is what about giving? Perhaps you hit the enter key too quickly. Is there more to that question? We talked about gifting and divestment in the presentation. Right. Getting under $2,000 if over and not in the home. You can't gift anything away without getting a penalty. So if you get over above $2,000, you've got to have a plan for getting through a penalty period if you give anything away. Many people say, well, I've heard that you can give away up to $15,000. Actually, it's no longer 15,000. It went to 16, then 17, and now it's $18,000 a year that you can give for gift tax purposes. I want to emphasize, that's for gift tax purposes. It's not for Medicaid. Medicaid does not have any amount that you can give safely without having a penalty. Medicaid, let me say that again. There's no amount that you can give and be safe from penalty for Medicaid. You cannot gift any amount and be safe from the Medicaid penalty. Can you just spend it every month? Yes, that's the idea. If you need long-term care, your expenses are going to be way more than your income, so you just have to spend it on your care. Once you receive Medicaid, they will tell you are expected to kick in your whole paycheck to your care, and then they make up the difference. Can you add to an MAPT? Yes, you can. So especially if you're doing a pre-plan, let's say you're pre-planning, you're healthy, you put your house in the MAPT, and then 2 years later, you become more comfortable with the idea, and so you take some of your investments. You cannot put an IRA, though, or a 401k in an MAPT. Those must be held in your individual name, so that makes it hard to plan for those. But you can take stocks and bonds and whatever else you might have, bank accounts, cash, and you can put those in the MAPT. And within the MAPT, your children can invest in stocks, bonds, mutual funds, etc. They can have bank accounts within the MAPT, etc. So yes, you can take as many gifts as you want to the MAPT, but that gift then has another 5-year look back period. So each gift has a 5-year look back period. And then when you apply for Medicaid, they look at that 5 years and they count all the gifts that were made within that 5 years against you. Okay. I'm not sure if I answered the question that you were asking. Hopefully that made sense. All right. So are there strategies for IRA reduction if that's where all the money is? Well, in a crisis plan, you just have to cash out the IRAs and pay the taxes. IRAs, most of them, unless it's a Roth or something, IRAs have not been taxed. So they have to be taxed one time or another, whether it's during your lifetime or after your death. If it's a crisis plan, sometimes what we do is we say you got to cash in your IRA so we can save it. So that is part of what you lose in order to save. Sometimes you have to lose something in order to save something else. So the taxes are part of the cost of doing this planning, especially in a crisis situation. Rarely in a situation where we're doing pre-planning, we rarely advise people to cash in their IRAs just because it costs a lot in taxes. We don't know whether you're ever going to go into a nursing home, and we don't want to just do that without knowing what's going to happen. So only in a crisis situation, oftentimes we have to tell the person you need to cash in all your IRAs, and we do it because the tax is much less than losing everything. There are methods that we can save an entire IRA if your spouse is not needing care. So the spouse that needs care can, in a very complicated way through an annuity, give their IRA to a spouse, which is not normally, you can normally not ever be able to do it. But when the spouse gets it, over time through the annuity, the taxes have to be paid at that point. So you can delay the taxes for a few years, but you can't avoid paying the taxes on the IRAs. You just can't unless you give them to a charity, which would be considered to be a divestment, which causes a penalty. Is MAPT different from a regular trust? Well, it's different from a revocable living trust. If you consider a revocable living trust a regular trust, it's the most common type of estate planning trust. A revocable living trust, or RLT, yes, it's different from that. The main difference is it's irrevocable. You can't change it. And the other difference is with the MAPT, you have to turn over control to your kids, whereas in a revocable living trust, you keep control for your lifetime. Okay. We are close to the top of the hour. My voice is starting to give out. Oh, you see, we have another question. Happy to answer this one, and then we'll close out the session. So the question is, what if you set up an MAPT and you own your $300,000 home? How does it work if you are still living in the home and do not want to sell it? We do this for clients all the time. They put their home in the MAPT and they just continue living in it. Now, technically and legally, the MAPT owns the home, but they still live in it. They don't pay any rent. They do have to pay the taxes. They have to pay the upkeep on the home, but the home is no longer a liability if they need nursing care. So you just put the home in the MAPT. You entrust your kids essentially with the power to sell it, and they don't. You just keep living in it, and you live there as long as you can. And then if you have to move out at the end of life, kids can sell it, or they can keep it in the MAPT until you pass away, which is the most common. Actually, what happens is the kids just keep the home in the MAPT. They wait for mom or dad to pass away, and then they either move in or they sell the home and divide the proceeds. All right. This has been great. I really appreciate your questions. I hope it's been helpful, and I want to encourage you to, if anybody in your family is concerned about losing assets at the end of life, where so many people do lose assets, then you should make an appointment to talk with me. You can message Laura. I think she has put up things in there about how to make an appointment. I'm pretty sure in the chat and the handouts. I encourage you to make an appointment. It doesn't cost anything. We can talk to see whether anything can be saved. And if so, then we can work out something to work for you and make it so that you have your plan instead of relying on the government's plan, which really is not to your benefit. It's more to the nursing home's benefit and the county's benefit. So thank you very much for your time, and give us a call. We love to help.